Okay, good afternoon, everyone. Thank you all for joining us today. My name is Rosemary Hannum, and I'm the director of the Sandra Rotman Centre for Health Sector Strategy here at the Rotman School of Management. Our center is really pleased to be hosting today's panel event, Intellectual Property Essentials for Health Sector Startups. Although this event is taking place virtually, we wish to acknowledge this land on which the University of Toronto operates. For thousands of years, it has been the traditional land of the Huron-Wendat, the Seneca, and most recently, the Mississaugas of the Credit River. Today, while we are meeting virtually, Toronto is still home to many Indigenous people from across Turtle Island, and we are grateful to have the opportunity to work on this land. We have a terrific session lined up for you. It's an introduction to intellectual property rights, essential for the success of any health sector startup. As many of you already know, IP is a complex and nuanced topic. Since we only have an hour, our aim is to provide you with foundational knowledge to get you started on the journey to commercialization. Our faculty lead, Alberto Galasso, has prepared an overview to kick us off and invited 3 experts to share their insights. Let me introduce them to you. First, we have Tamara O'Connell, an intellectual property lawyer and a patent agent. She is currently patent portfolio manager at U of T. She's going to speak to us about accessing university patents. And next, we will hear from Steve Leonard, co-founder of Cavella, a Canadian diagnostics company and a registered patent agent at Hill & Schumacher, a boutique IP firm in Toronto. He'll speak to us about building a patent portfolio within your healthcare startup. And finally, we have Ella Corrett-Smith, co-founder and chief business officer at Viraco Biotech, who will speak to us about the management implications of IP and making the most of your IP portfolio. And our host and moderator today is Alberto Galasso. He's a professor of strategic management here at Rotman, where he also holds the Rotman Chair in Life Sciences Commercialization. He's an expert on IP, and his research agenda focuses on the determinants of innovative activity, the management of innovation, and the functioning of markets for technology. Alberto's going to take it from here, but just before he does, a few words about our center. We're supported by the school and the Rotman family, and we focus on 3 main areas: research and thought leadership on health sector challenges, educational programming for emerging and senior leaders, and outreach activities like this one. And on educational programming, our Global Executive MBA for Healthcare and Life Sciences, designed for working professionals across the sector, is recruiting for the fall of 2023. Our 6th cohort will begin at the end of October. I'm going to put a link in the chat in case anyone is interested in learning more. And today we're a bit tight on time, so we've curated some questions for the panelists ahead of time, and we will not be taking questions during the session. So if anyone has one, please send it to me by email. I'm going to put my address in the chat, and we'll do our best to answer it after the session. And now over to you, Alberto, and I invite everyone to sit back and relax and enjoy our session on IP essentials for health sector startups.
Thank you. Thank you so much, Rosemary. So let me just share my screen. Can you see my screen?
Yeah, it looks good.
Okay, so that's great. And I'm just giving a very broad overview about the concept of IP and setting the stage for the experts that are going to talk after me. So let me start really broad with a definition of what is intellectual property. There are a lot of definitions available in business books, in law articles, and in economics textbooks. This one that I'm using as a definition was provided by Landes and Posner, who are 2 leading law and economics scholars that define intellectual property rights as legal regimes of property rights covering ideas, invention, discoveries, symbols, images, expressive works that have an existence separable from the physical embodiment. So the idea is really we're talking about property rights, but not of tangible things, of intangible things. And while it's typically very easy to think about ownership of something that is tangible, especially if you think about expensive things that you buy a car or you buy an apartment, there are like documents that show that you are the owner of that particular asset and that people cannot use it without your permission. When we talk about IP, we're talking about ownership of something intangible, information in particular, and from from the perspective of businesses like life sciences businesses, information required to produce new technology, new products, or new processes. And the fact that we are talking about protecting information creates challenges from a managerial perspective, because relative to tangible things, when you talk about information and knowledge, it's harder to really describe what exactly you're protecting. It's harder to write in a contract what you're actually protecting, or to enforce property rights that you may have on this information. There's a lot of type of intellectual properties, a lot of classification and taxonomies available across different books. I want to start with one that is, very common. You find it, for example, in intellectual property offices' websites. There's a typical distinction between what is called industrial property, that includes what are patents, trademarks, and industrial design, or these industrial designs in some jurisdiction like US are called design patents, and copyrights, that is instead protection for creative works like music, books, and movies. The typical approach, especially in business school, is to say, okay, copyrights are very important if you are in creative sectors, like if you are a producer in Hollywood or a book publisher. But for most businesses, like in medical device and pharmaceutical, it's patents that are the key intellectual properties. That, there is this is definitely right if you look at the data, but let me add a caveat here. In the modern economy, copyrights are becoming more and more important. Think about a startup. Most startup, you need to, your web page is one of the most important marketing tools that you have. So navigating there, copyright issues related to the images or the material that you post is really important. And also with new digital health technologies that have been developed, there is the issue that software potentially can be protected both by patents and by copyrights. So thinking about that is also something that often is on the radar of some life science companies. Because we have only 1 hour today, we're going to pay most of the attention to patents. And but we're going to probably touch some other form of IP in the Q&A at the end, if you have time, maybe talking about trade secrecy. So what are patents? For those of you that have never seen a patent, patents are documents like the one that I show you here in a picture. Those are documents given by specific countries. So the one that I show here is a patent granted by the United States. So it's an American patent. And if you own a patent, it means that you have the right to stop others from making, using, selling the product or the process in the country that granted the patent to you. So if you own this patent, you can stop other people from using the technology without your permission for a period of time. So it's a protection that is lasts for a specific period of time, that is 20 years, typically computed from the date of the filing of the patent. As you can see, there is a lot of information on patent documents. Typically, they are like, almost like an academic paper. They're like 10, 15 pages long. They have information clearly on the technologies to be protected, with drawings and a description of the technology. But they also have additional information that is important, especially, from my perspective, from the business side. There is information on the company owning the patent. In this particular case, it's a Apple patent. There is information on the inventors that were involved in developing the technology. The information location. So you don't only know that Apple developed this technology. This is the cover of an iPad. You know exactly the person that were developing the technology and where they were located. So you may have a sense about the lab structure of the company. So in a sense, from a business perspective, patents can give you a lot of information that can be useful to understand what other firms are working on, what are their specialization, what type of technologies they are investing on, and they may give you an idea of products that will be on the market, in the future. Each patent has an identifier number. This is an important number that uniquely identify the IP and is typically the one that is used in legal documents when you have signed, for example, a license. And this patent, for example, was granted in 2012. But if you look at the date in which it was filed in 2010. So it's a long process, and some of our speakers were going to tell us a bit more about this process in the and during the panel. And you know, one of the idea about doing this this session was really to try to make clear that, you know, it's important to take this seriously because it can take a lot of time, and it's important to make sure you do all things you can as a startup to avoid unnecessary delays or even rejection in the examination process of the patent. So why is it important to think about IP if you're a startup? There is a body of evidence in across different disciplines, across economics, management, and law, showing that having a strong IP, in particular at the very beginning of the life of a company, can make the difference. Here I summarize findings from a study conducted by researchers at Harvard Business School, NYU, and the Stockholm School of Economics. They look at American firms filing their first patent and compared with those that were not successful in their first filing. And find, you know, substantial differences in the growth rate of the company. And typically, it appears that these differences come from an advantage in raising money. Having an IP, in particular a patent, can give you an asset that can be of interest to investors, or also can be used as collateral for people that want to give you money in the form of a loan. You may be a bit skeptical. You see these numbers, you may say, okay, the firms that get patents can be different from other firms in all sorts of dimension. For example, they can have better founders, they can have better technology, and so on. Just let me say this study was really careful in trying to remove a lot of potential confounding factors. For example, they look at companies that are lucky in the sense that they are assigned, their patent application is assigned to examiners that tend to be fairly lenient in granting patents. With companies that are unlucky, they're assigned to an examiner that tend to be fairly harsh in the examination process. And look at this difference. And also, you know, in this kind of almost random assignment, they find substantial effect in terms of success of the company if they obtain the patent. So suggesting that there is something there. Companies that take their IP seriously, especially at the beginning of the life of the company, seems to do much better in terms of growth, survival, and even reaching the IPO stage. So what we're going to talk about for the rest of the panel, we structured the presentations following a theme that we observe quite often as natural for life sciences companies. In particular, I interacted with several medical device and pharmaceutical startups that go through the Creative Destruction Lab. That is a program that we have here at U of T, and is now also available in several other locations in Canada and outside Canada, that help early stage company to grow. To discuss their IP issue. And I noticed essentially three main pattern. Very early on, a lot of life sciences companies tend to be, because they tend to be founded by people affiliated with the university, either professor or students or researchers. There is a lot of question about, okay, what is the ownership here of IP? How much is the technology that developed owned by me as a researcher? How much is owned by the university? What is the process that I need to follow in order to make clear what is the status of the intellectual property? And here, Tamara is gonna give us a presentation about that. Then as the company tend to grow, they tend to start thinking about filing their own patents. And here there are always a lot of question about, okay, when is the right time? What is the right process? Who should I, hire as agent? What type of technology should I patent? What kind of technology maybe I should not patent, and so on. And here, this is going to be the central theme of the presentation of Steve. And then as the company tend to grow and they have, a portfolio of patents, then there is the final big question about how you monetize these intellectual property, how you manage that, how you transform, a patent into a commercialization strategy. And here, Ella is gonna provide insights on these topics. After the three presentations, we're gonna then discuss together as a panel a few issues that are, related to different aspects of managerial technologies. But this was, this concludes my presentation. So let me now stop sharing, and I let Tamara take it from here.
Great, thank you, Alberto. So hi, everyone. I'm a patent portfolio manager at the University of Toronto, and I fall under the Innovations and Partnerships Office. So I thought I would start off with a brief overview, because essentially the IPO is the gateway to access university IP, and this will sort of set the context for some of my remaining slides. So there are three teams in the IPO. There's partnerships, innovations, and entrepreneurship. Partnerships works with industry and others to secure funding and other resources that support U of T researchers. Innovations is the team I'm on and will sort of be the focus of my slides today. And our responsibility is to commercialize U of T IP, and that most commonly occurs by patenting to protect the IP and licensing it out to a company, for example, a U of T startup. And there's also a very large and active entrepreneurship community at the U of T, and there are a lot of great resources that they offer U of T startup and spin-out companies. Includes IP education programming, there's the U-Test incubator, mentorship, and lots of other great resources that support company formation and growth. So Alberto touched on what intellectual property is, but how do we define university IP in particular? And I'm going to focus in on inventions, specifically patentable inventions, sort of as Alberto alluded to. And so the answer to this question can be found in the U of T inventions policy. And this is a pretty comprehensive document. It's available online. So I encourage anyone who is working at all with U of T researchers or research to familiarize themselves with that document. I'm just highlighting three important aspects here. The first is scope. So the policy covers inventions that are made or developed using university resources, and that's pretty broadly defined, and it also includes funds that are administered by the university. So any research grants that are administered by U of T, any work that's done in U of T labs, all of that would sort of fall under the scope of the U of T invention policy. Under the policy, there's also an obligation on U of T inventors to disclose those inventions to the IPO. And that is regardless of where ownership ends up. And on the ownership point, at creation, the invention is co-owned as between the university and the inventors, but the university has what we call an inventor's choice policy. And essentially that means that the inventors can choose whether they want the university to transfer their stake in the invention to the inventors as individuals. And in that case, the invention becomes wholly inventor owned. Or the second path is for the inventors to transfer their ownership stake to the university, and the invention then becomes wholly university owned. So there are pros and cons to each of these two paths. It's something that sort of requires careful thought. There are different impacts in terms of things like the revenue share of any potential downstream revenue, depending on which of these paths that is chosen by the inventors. When the invention is university owned, that does allow for access to some of the resources that the Innovations Office can provide, and that includes IP protection and patent filings, as well as on the commercialization side of things, marketing and licensing expertise. So once you've submitted an invention disclosure form, this is sort of an overview of the process. Following research, the invention disclosure form is submitted to the IPO. There's specific sections that are laid out, and I'm going to go into a little bit more detail about what some of those requirements look like. If the invention is not going to be owned by the individual inventors, then the IPO does an assessment, and we take a look at the technology from both an IP and commercialization perspective and look at the prospects there. And if we take on the invention, then in that case, the invention gets assigned to the university. In that case, then the innovations team is involved in the commercialization process. There are two primary goals there. The first being IP protection. Again, that's more often than not patent protection, but not exclusively necessarily. And then finding a receptor for the technology, and that typically is in the form of licensing the IP out to another company. So that can be an established industry partner or a U of T startup company. So let's take a closer look at the invention disclosure. So again, this is a form. It's really important that this is completed carefully and with attention. And it's certainly something that our office helps U of T inventors with. I just wanted to highlight 4 issues that come up often, and you should be aware of at as early a stage as possible. The first one is identifying inventors and contributors. So this can be quite a difficult analysis. Anyone who has made an inventive contribution to the conception of the invention should be listed as an inventor, but that also requires a definition of what the invention actually is, and can be a difficult analysis to do. So we can certainly help with that process. A list of some of who those individuals might be is here, certainly not an exhaustive list, but it's really important that the inventors are identified correctly. If not, then that can have an impact and potentially jeopardize the validity of any future patents on the invention. Can also cause some issues in terms of raising questions as to ownership of the IP and who owns it. That can cause a multitude of different issues. One example is when an investor is doing their due diligence down the road, it's certainly a big red flag for them. So really important aspect that needs to be done right. Another section that is required in the invention disclosure form lists the funding sources for that research. And so it's important to make note if that includes sponsored research. So what I mean by that here is if there's an engagement with an industry partner who has provided funds for that research. And so that might be covered by way of a sponsored research agreement. And the reason why that's important is because there may be IP terms in that sponsored research agreement that indicate that the sponsor has certain rights to the IP. It's sometimes referred to as foreground IP. And so the IP might be encumbered in that way. And so, we need to make sure that all of that is in order. And similarly, if there's any sort of interinstitutional collaboration, might also lead to various encumbrances. U of T researchers are often cross-appointed at other institutions or collaborate with researchers at other institutions, such as hospitals is a common example. And each of those institutions has their own IP policy. So depending on where the work was completed and who did it, we may need to take that into account. And so that can be handled by way of an interinstitutional agreement as between U of T and the other institution to outline what obligations each party has, who's responsible for what in terms of IP and commercialization in particular. And then finally, wanted to note here the importance of flagging any public disclosures. So this is both any public disclosures that have already happened if the invention has been shared publicly in any way, as well as any planned or future public disclosures. Obviously in an academic environment, publication is very important in academic journals, at conferences, etc. And that activity isn't necessarily at odds with pursuing IP protection and commercialization, but often it really comes down to timing. And so the takeaway here is engage with IPO as early as possible and just keep those lines of communication open so that we know if and when you're planning on sharing information related to the invention publicly in any way. So an invention disclosure has been submitted. What happens in the commercialization stage? So I made note of the importance of IP strategy, coming up with a plan to protect the IP and executing on it. Patents are really the most common form of IP, in large part because if this work is going to be published on anyways, the patent document will also eventually publish. And so that can kind of be a well-suited form of IP protection, but it's certainly not the only one. There's copyright, know-how, trade secrets, all sorts of other avenues of protection that can and should be considered. And then the step of really getting the technology out of the lab from the university into a company that can actually market is typically done by way of optioning or licensing the IP into a company. And that can, of course, include a U of T startup. And there's a lot of sort of marketing and commercialization efforts that go into that process to try and commercialize. And there's a great deal of licensing expertise that the IPO can provide to make those relationships happen and help grow the startup. And so in terms of what the role of the IPO and the inventors are at this stage, for university-owned IP, IPO is putting in resources into all of these activities, but it really is a collaborative exercise with the inventors who have their technical expertise and knowledge of their industry. And so we work together to try and achieve all of these goals. So finally, just wanted to provide a bit of an overview as to what this process can look like at a high stage, and just reiterate some of the earlier points. The importance of talking to the IPO as early as possible. Again, this idea of getting the timing right can be pretty critical to ensure that proper IP rights can be obtained. Assessing and protecting the IP, determining what is the best path forward for that, whether it's filing for patent protection or otherwise. Networking and seeking input is something that can be happening at all points during this process. In the context of company creation, you want to be planning your business, certainly talking to potential customers. And then when it reaches a point where the IP is actually being transferred in some way into the company, that is usually in the form of an option or a memorandum of understanding or some sort of IP license. And once that is achieved, then you'll be in really great shape to pursue various fundraising avenues. So with that, I'm going to turn it over to Steve, who will talk a little bit more about IP protection and building a patent portfolio.
Okay, thanks a lot, Tamara. So yeah, I'm Steve Leonard. I'm going to share my screen here. Okay. Oops. Okay, everyone can see my screen? We are good? Okay, great. So yeah, so again, Steve Leonard, I am a patent agent. I'm also co-founder of a diagnostics startup. I absolutely love working with the medtech community on protecting their innovations and building patent strategies. It's a ton of fun. Today, I'm going to talk to you about building a patent portfolio in a healthcare startup. And this is something that, we could take an hour or we could take several sessions to discuss. Today, we're going to do it as a crash course in 10 minutes. So buckle up and we'll see how we do here. So I'm going to first talk to you about the process that I take in preparing and filing a patent application. You saw Alberto's previous example of a Apple patent for a holder for the iPad. How did it get there? What was the process? And this has changed for me. When I came out of academia, I did a PhD and got into patenting after an academic grad school phase. And my concept of that was really shifting coming from preparing papers to filing patent applications. And the process really got inverted as I went along. So here's the process that I take in preparing a patent application. So the first step that I take, so just want to make sure everyone can see my screen, right?
Yes.
And it's okay. And it says steps. It's just not forwarding on mine. Okay, there we go. You can see it now. It's moved on.
Yes.
Okay,
yes.
perfect. Thanks. It was out of sync on one of my screens. So the very first stage is, and Tamara brought this up, so I'm really glad, because if the one thing you leave here with is making sure that you're aware of disclosures and filing a patent application before a disclosure, is identifying disclosure deadlines. So realizing, even if you've actually passed one already, or if there's an upcoming deadline for a public disclosure, making sure you've got a plan to file your patent application before that deadline. Number two is what you would consider, drafting patent application. Conventionally, it's having an invention disclosure that describes the invention in technical detail, has some drawings, has some description as well of what you think is inventive. Now, this is just the starting point. This is before you've gone to the patent literature or the academic literature and challenge yourself to say, wait a second, is this actually patentable? So the invention disclosure is just the beginning. And then step number three is the search phase, where you go and you ask this question and you find out, is it out there? Has someone actually described your invention before? Or are there multiple references out there that somebody who's works in your field would be able to put together and arrive at your invention in an obvious way? So once you've done that search analysis, you kind of step back and you say, wait a second. So originally my concept of the invention, what I could patent is out here, but I realize now it's changed. It's in here. So you've got a better sense of the scope of what's patentable. So getting to this step 4, getting to this step of understanding with your invention, what scope of patent protection I think I'm entitled to. This is the goal. This is like the challenging part, getting from number 1 to number 4. It's a very creative, nonlinear phase. You're trying to think about what the different parts of your invention are that could be patentable. You're challenging yourself by going to the search, to the literature. You're analyzing that. I love this phase. It's very creative. But once you get to number 4 and you know that, now you're in a position to draft those claims. So if you look at the back of that Apple patent, you will see a number of really obtuse run-on sentences with all sorts of strange language that are numbered. Those are the claims. That's what the whole patent is about. So those claims are the legal line in the sand that if you cross that line, now I've got a stick that I can whack you with and say, hey, you're infringing my claim. I can sue you for infringement. So it's this exclusionary right. And once you figured out the scope of the invention, you can draft those claims, and hopefully you've got a broad claim that's going for big protection, and then a number of dependent claims that you'll see. These are like claims 2, 3, 4 that are ideally strategic fallback positions, because maybe your search wasn't complete, or maybe there's some prior art that you didn't see, and during examination, one of the broad claims gets knocked out, and you've got these additional claims to fall back on. So once you've got to that point, you've drafted the claims. So that's all we have in terms of the patent application, just the claims. But now we've got a skeleton. We've got the structure, this key structure of the patent. And the drafting of the patent application, which I used to start with after coming out of academia, that is done after the claims. And the claims provide the scaffold to draft that application. And you might say, well, what's the point of the description and the figures if you've got the claims? Well, you don't have a valid patent unless you've supported the scope of those claims with the description and the figures. So the whole point of all of that description and all of those figures in a patent application is only to give the claims support so that they're valid. So we don't want to put anything in the description of the figures that isn't going to be in our claims. Otherwise, we're giving away intel for free, and we certainly don't want to do that. So now we've got our patent application, we've got the claims, we've got the description, we've got the drawings. It's all perfectly put together. The description and the figures are supporting our claims. Our claims have the appropriate scope based on our search. We're good. We confirm the inventorship because the inventorship is based on who invented, who can point to claims that they invented. We confirm ownership, so we know who the applicant is, and we file. Okay, so now you see the process that I go through. So your first patent application, so we're going to just talk now about what your first patent application, some characteristics of it. So it's likely a US provisional application, but the word provisional, don't take that wrong. Don't think that means that you can do a half job or something that's not complete. A provisional should be drafted carefully and thoroughly because it is the foundation. And if you're going to have claims that issue off this patent application later, you're going to be relying on this initial date and you want to make sure you have full support. So do a really good job on that provisional. It's often a kitchen sink. So often as a startup, you've got so many different inventions, maybe a lot of different concepts. You pack them all into one provisional application, you file it. That's okay. That's perfectly good to do. And that can actually split. It's very cost effective and strategic, and it can split off to multiple patents later on. It's key for leverage. So when you're going for financing, you're going for your seed financing, investors are going to want to see that you've got a patent application filed. And if you can get a US allowance, so if you can try to expedite the allowance of a US patent application, maybe between seed and Series A of your venture, that can be very helpful as well. It can also de-risk early engagement with potential strategics and development partners. So early on, you're wanting to get out there, you're wanting to make your name, talk to different people, develop relationships, maybe do some pilot testing, all that kind of stuff. You want to have some kind of security for your IP. So it's really important to kickstart those discussions. And just so you know, like when you go out and talk to investors, they're probably, and they say, have you got a patent? They're probably not going to do a deep dive on it because it's too expensive for them to do at the seed stage. But it's still up to you to be able to tell them about it. You can say, hey, I've got this great patent. I think I'm going to cover this, that. So you can have a narrative that you communicate to them that conveys that value. And it might not be the most valuable IP in the company. So just keep this in mind as well. Startups usually have pivots. They rarely end up in the same place where they had set out to when they start. And often some of the key IP comes up later on during commercialization when you're designing for manufacturing or you're doing your MVP or you're in the clinic and you realize some new things are important or new customer workflows that you hadn't thought of or marketing feedback. All of these things can lead to further IP that comes down the road. So this isn't going to be your only critical IP document. All right, so what's important early on? Some things to really get right. Again, file before public disclosure. I'm going to repeat that. Number 2, secure and clarify the rights in the invention as early as possible. This is the one thing that early investors are going to check to make sure that you've got rights to your invention. Find good patent counsel. So that means someone who's engaged, who you enjoy working with, who is hopefully some kind of specialist in your field. And you talk to people, so you get some recommendations. And work hard with them to prepare a patent application. Don't just hand off the description and say, please file a patent for me. Engage deeply with them. The more you get engaged, the easier it is for them to do their job and the easier it is for them to help you create a really good patent document. Develop and refine a strategic patent narrative to excite investors and employees, like new employees. This is key. So even though it's early on, you can have this kind of like elevator pitch or value proposition that is about your IP, that excites people, that is tailored to your situation. So try to craft that. Avoid over quantifying IP risk early. When you have so many other high stakes, high risk fires burning, and the direction of the company may change. So don't go too crazy thinking about freedom to operate or even patentability. Get that initial patent filing in. You've got so many other issues like product market fit risk. You've got risk in terms of regulatory, just financing risks, so many risks. And be smart about how you spend your IP dollars. Work hard to get that initial high quality filing in, but make sure you're spending your IP dollars wisely. Okay, one more. IP strategy. I just want to say some thoughts about IP strategy. So IP strategy is not just something for later stage companies. It's something that you should be thinking of during all stages of the company growth. An IP strategy considers all forms of IP, Alberto had mentioned several of them, and how they each provide strategic value to the company, almost like they're all different employees, creating value in the company. And a good IP strategy also provides a solid plan for the future. Now, the goal of an IP strategy is to maximize value creation by aligning IP protection with commercialization, financing, and regulatory strategy. That's my definition for medtech. Different people have different definitions, but the point of it is that IP strategy doesn't live in a little silo. It's integrated in the company. It's aligned. You've got an IP timeline that's aligned with commercialization, regulatory. It's about leverage for financing. It's about all these things. And when you do that, it's exciting, and you bring in all the different stakeholders in the company to align on IP strategy. And finally, consider IP through multiple lenses, not just the lens of the researcher, which you're probably starting. Like, I want to protect my idea. No, think it through the lens of your customer. What's important to your customer? What barriers are important to erect from your customer perspective? How about a competitor? What claims can you draft that are going to be the biggest problem for a competitor to see? Or an investor? What is the if you're getting VC money, like, you want to have claims that are going after the big stuff, right? Because that's what they're investing in you. That's why they're investing in you. And even from an acquirer, what's the scope of protection, which jurisdictions are going to be important. Thinking about it from these different lenses can be super helpful. So I'm going to stop here. Hopefully I didn't throw too much at you, but hopefully this gives you some ideas of how to start off crafting a patent portfolio and an IP strategy for your startup. Okay, great. So I'm going to hand off now to Ella. Thank you.
Thanks, Steve. You've touched on a lot of things that we'll talk about in the next few minutes. I'm going to share my screen, hopefully. So hello, everybody. I am Ella Kretz-Smith. I am a co-founder and chief strategy officer at Virka Biotech. And also have been operating a business development and biotechnology advisory firm called EKS Business Development for the past 10 years. And so what that means is I've seen a lot of different companies go through the different phases of commercialization of their IP. And of course, in the biotechnology space, as both everybody before me alluded to, intellectual property is one of the key assets that you will have as a company. And so what I want to talk to you about today are some practical elements of making the most of your IP portfolio. And I hope that everybody can see my screen. So I think the bottom line is that having a patent is really table stakes for a company, especially in the biotechnology sector. You have to have it, because if you don't, then you don't really have a company. But having a patent or getting a patent is step one. The real work comes in actually building out the company. And so as you start thinking about the company that you're building around a piece of intellectual property, you really need to think about this on a 5 to 10 year horizon, or whatever the lifetime of your company might be. It might actually be longer than that. And specifically what I mean is considering elements of cost, of proper management of the IP, and of the further build out and further use of the IP. And these are all issues that are not really describable in counted minutes. But what I think is really important is that you're thinking about the company itself has to build in a significant proportion of budget into your thinking for intellectual property, both for filing, for maintaining, and future build out, because that is going to be a key expense for you, and you're not going to, you don't want to go crazy, as Steve just pointed out, but you do really want to think about what your budget for IP is going to be, because it's going to be substantial compared to the rest of your budget and the rest of your operation. Now, the next thing is talking about what does it mean to have a patent. So preventing others from doing what you are doing is really only part of the picture. That's what a patent gives you. It gives you an ability to prevent others from doing the thing that you have set out for yourself, or the thing that the scope that you've outlined for yourself. You don't have to go crazy of this early on, but you do have to think about whether you have freedom to operate, or whether you actually do need additional licenses or additional rights to be able to do what you're doing. And I think it's important to note it here. I don't exactly know who the audience is, but my assumption is a lot of the audience might be academic. And as a researcher, as an academician, you probably don't have to think about freedom to operate very much. You probably can go ahead and build out your invention and use it and do research with it without really thinking about freedom to operate. But as a commercial entity, it's absolutely critical to think about it, because that is going to make or break your business. If you can protect your invention and stop others from coming in and doing what you're doing, great. But if you can't actually implement what you need to do because you need other pieces from other companies or other researchers or whatever that might be, you're not going to be able to actually commercialize. Because as soon as due diligence happens, as soon as you want to monetize, as soon as a partner comes in, they're going to see that. They're going to find out that you actually can't monetize because you don't have the right to actually do what you set out to do. And that could be very, very problematic for you. So you do really have to look at it as a commercial entity. Now, monetizing is, of course, the point. We all want to build knowledge, but really, you're really creating a patent in order to monetize it and to have a business and have some sort of monetary outcome. So for most biotech companies, that means licensing. It's unlikely that you are actually going to take a product all the way from research to a customer, which means a patient, because all of that development is going to take time, it's going to take a lot of dollars. And in most cases, in biotech anyway, therapeutics, what I mean, you're going to need a commercialization partner to help you do that. So the key here is considering who this might be for you early. And if you think about it, then you can think about it, and Steve mentioned it as well, which is great. You should think about what might be critical for them. And IP is going to be critical for sure, but it may not be sufficient. There may be other elements of your business or your technology that may be important to your future partners. I always talk about this in this kind of crowd. You do really need to balance secrecy, with getting feedback. A lot of researchers will want to not talk about what they're doing because they're afraid that somebody else is going to come in and take their idea. And they're right. You shouldn't publicly disclose things until you have it properly protected. And you shouldn't do it thoughtlessly. But I am of the very strong opinion that you have to have a certain amount of conversation about what you're doing. And it could be, to a degree that's not confidential, but it has to be something, because you're going to get feedback from your potential partners. They're going to tell you what they're going to be looking for. And then you're going to be able to make decisions based on that. If you don't talk about it, you will never know. And so you really have to strike that balance. And lastly, on this point, and you can talk about this one for hours too, is what's the value of that license? I think somebody put that question in the chat. It's a really difficult question. Value is what the market will bear, fundamentally, right? And that really is the same for IP and licensing. There are industry standards, but those should be used as a reference only. You really can make a call based on reference standards. Now, I want to address this because we've been talking a lot about ownership of IP. In biotech, there are two, and not just biotech, other industries as well. Ownership versus control. Who cares, right? The spoiler is the following. As long as you have control, you don't need to own it. And this goes back to a lot of the things that Tamara was talking about. For example, UFT ownership versus inventor ownership. For companies that are trying to commercialize IP, as long as they have control over what gets filed and how things get defended, I don't think it matters who actually owns the IP. So think about that when you're actually negotiating with universities or whoever else around the basic patents. And so here's an example of Virica, so the company that I co-founded from the Ottawa Hospital Research Institute. We have an original patent estate that we licensed exclusively from the OHRI. OHRI owns the patents, Virica controls the patents. That's all we care about. We don't need to own. Now, we're commercializing these patents through offering clients products based on the original IP portfolio. And because these are actually products for sale, the license is implied in the sale, meaning if I sell you the product, you get the license for using that product. But we also have other agreements that are more along the lines of collaboration and research agreements that make use of the background IP and then have the opportunity to actually generate some new foreground IP and maybe some IP that will help us go forward. And so that is actually interesting and important for us as well. And we also have some unique opportunities to license commercial specific formulas, et cetera, to partners, kind of more standard biotech license. So the strategy here is rely on the background IP, but always think about building new IP and recreate that new generation of IP in order to build on the technology going forward to continue commercialization and continue building value. So that is absolutely critical. And frankly, continuing to scan what others are doing and understanding what they're doing is also part of it, because technology evolves, companies evolve, and you need to know what's around you in order to be able to build what you have and continue to grow the value of each company, of your company and your IP portfolio. If you have any further questions or would like to talk further about Virica or any other elements of commercialization, happy to do that. That's my contact. If anybody's looking for additional conversation, happy to have that. And I'll pass this back to Alberto for a question period.
So thank you so much. It was a very, very insightful set of presentations. We don't have a lot of time for questions. I have seen several emails that we have received. I want to make sure that we're gonna forward the email to the panelists in case they want to follow up with you directly. I think given we have only 5 minutes, let me ask you a question to all of you, since we receive emails asking about international patent protection. So Steve was mentioning this idea that typically you start with a US provisional, but we know that when we talk about pharma and medical technology, typically they're big markets, and if you want to have a commercialization partner, these typically are big firms that operate all over the world. So do you have any suggestion in thinking about what is the right geographical scope? What are the issues to consider in deciding how broad the coverage should be geographically? I don't know who wants to start. You probably have a minute each if you want to give your thoughts on this.
I can jump in quick.
Yep.
So yeah, it's really hard to do, and it depends on the market and the value. A PCT application is good, and then it gives you another year and a half to make that call. It's really what you want to do is try to put a lot of work into understanding the market. So working with the marketing and the biz dev team to understand. And then in terms of trying to put a plan together, what I often do or suggest to my startup clients to do is to look at the strategics in their space, see where they're filing, see what an acquirer might want based on where they're filing, or look at what other scale up companies are doing in the space. And then just to be cognizant that it might feel good to file everywhere, but it becomes a massive financial burden if you do it too early. And you really need to balance the risk of having a super expensive patent portfolio versus the benefit from having broad coverage, and be very, very cognizant about that.
Maybe I could just add, I agree with Steve. You really have to be cognizant of the cost. Obviously you want to cover the main markets. I think US Canada, no brainer. There actually is a new ruling, and I can't remember what it's called. It just slipped my mind, for Europe, where you can file a single application. And that actually, I think, is going to be a huge benefit for early stage companies. And somebody who's a patent agent maybe can say what that is called, because I can't remember. But certainly something that covers more countries, and you don't have to go into each country, so it saves you huge amounts of dollars.
Yeah, the unitary patent system that, yeah, it was released this summer. Yeah.
Yeah, quite awesome.
Yeah, I would echo again the costs. I mean, it's so easy for the cost to snowball when you try and file in as many jurisdictions as possible, and they can sneak up on you as well. So just be very forward looking if you're looking at going outside even 2 or 3 different jurisdictions. I would also just add, from the university perspective, we try and use mechanisms like Steve mentioned in international PCT filing to just try and defer those decisions as long as possible down the road. Eventually push comes to shove and a decision needs to be made. And at that point, just echoing the earlier comments in terms of where the customers are, where the market is, as well as the potential partners for the technology.
That's great. And there was another set of questions that essentially were asking. All of you were mentioning this idea that, in terms of budget and time, this is a process that require resources and also patience. There were some questions asking essentially to be a bit more specific, like if I'm a Canadian founder, how much resources should I have in order to file, some international patents, and also to maintain these patents, and also in terms of expectation, are we talking about, a year, a couple of years? I know there is a lot of variance out there. Each application is different, each patent is different, but would you feel comfortable to give some ranges to have our audience have a much more, a more precise idea of how much resources and time we're talking about?
I'm happy to start. Steve's probably closer to this than I am. Provisionals are pretty inexpensive, right? They can file a provisional 5 to 10K ish. I would say I've seen it sort of in that range, depending on how much work you can do yourself. In terms of maintenance, it really depends where you file. But it can be between tens and hundreds of thousands of dollars over the lifetime of the patent. Now, think about that as a 20-year lifetime, right? So your early investment is going to be quite small, but once the patent goes to national phase, right? Once it passes the PCT stage, then the expense kind of goes up, but then you can decide what you do. So you have some chance to figure it out, but early on, pretty inexpensive. Others?
Yeah, I would agree. At the provisional stage, it really depends. It really depends on how complex it is. I've had provisionals from 5,000 to 40,000. It's just all over the map. Yeah, like sometimes you have 10 inventions, right? And each of them has to be described thoroughly, right? So sometimes it makes sense. And then at the 1 year stage, filing a PCT, that's another $6,000, roughly $6,000. And if you've done a good job on your provisional, you're just refiling that as a PCT. So that can take you quite a while. And then, yeah, the national phase where you've got, if you're filing in Europe and Japan, some good healthcare strategic jurisdictions, you've got a lot of fees there. You've got translation fees. It can be easily $40,000 for several jurisdictions at that point. And then over the life of the patent, you can be talking $200,000-$300,000 or more. And, over a 20-year lifetime, that's, the cost of one of your lowest level employees in your company. So, think about that. Think about the work the patent family is doing for the company and the value that it's bringing. And, over the life, that's actually not bad if it's actually creating value. So that's how I like it.
Yeah, I'd also just add that, from the university perspective, part of our role is, at that early stage when you're trying to balance, to Steve's comment, a thorough and good quality provisional, but maybe you don't have a ton of money to spend and you want to do it a bit on the cheap. Part of the university's role when the IP is university owned is, we're taking on some of that earlier risk, and we're certainly, happy and in a role to care give the IP until such a time that, a U of T startup, for example, can take the reins and manage it sort of the way that Ella was describing.
Thank you so much. I think we learned a lot. And let me just, we are out of time, pass the video to Rosemary for a final comment.
Oh, thanks, Alberto. And thanks everyone for joining us. It was really hope you found it a valuable presentation. We'll be sending out the recording as well as the slides to everybody registered, and we'll also be posting it on our website so you can find it easily. And I hope you'll be able to join us at our next event on September 26th, where we will be doing our first digital health event, Digital Health in Canada, the current state, and a look ahead. So a final thank you to our panelists, and have a good afternoon, everyone.